Hello everyone, I'm Shehzhadee, the Managing Director of Shehzhadee Law Corporation. I practice family law amongst my other areas of practice. In today's video, we will be sharing about family violence. Section 64 of the Women's Charter defines family violence as the commission of any of the following 4 acts. Number 1, willfully or knowingly placing or attempting to place a family member in fear of hurt. In other words, you don't have to actually cause hurt, just threatening or putting the person in fear. So for example, if I smash a plate next to the family member, that would be sufficient to constitute family violence under this definition. The second act would be causing hurt to a family member by such act which is known or ought to have been known would result in hurt. In simple words, actually causing hurt itself. The third act which constitutes family violence would be wrongfully confining or restraining a family member against his will. So for instance, if you lock a person or you refuse to let the person leave a certain place, that act may constitute family violence. Or the fourth act would be causing continual harassment with intent to cause or knowing that it is likely to cause anguish to a family member. So if you persistently, by way of conduct and repetitively harass a person, causing emotional distress, that constitutes family violence. Now, I have set out the definition of family violence. What family violence does not include would be lawful actions used in either self-defense or force used to correct, basically discipline a child below the age of 21 years. So if a mother hits a child for the purpose of disciplining that child, that doesn't constitute family violence. Now, we have spoken about family violence and the hurt caused. So what is hurt? We know that hurt would be bodily pain such as bruises, bleeding. It also includes disease or infirmity. So if a family member threatens to spread or transmit a disease to you, that constitutes family violence as well. So what can a victim of family violence do? The victim can file an application in the family justice courts seeking a personal protection order along with other orders. So let me explain. There are 3 types of orders that a victim can apply for under this section. Firstly, a personal protection order. So this is a general order that prevents the family member, the respondent, from using violence against the victim, who is the applicant. So once you have applied for the PPO, you can also apply for 2 other orders alongside the PPO. What are these 2 orders? The first order is known as an expedited order or EO. So if there's imminent danger, you can apply for an expedited order. So for example, a woman is in fear of her husband. She fears for her life that he's been hitting her and she's scared that, one day he's really going to cause grievous hurt to her. She may then file for PPO together with an EO. Why? Because the PPO usually takes some time before the hearing is fixed. Once she applies for an EO, however, the judge gives her immediate protection, and this is a temporary order which the EO provides. Now, the other order is known as a DEO, Domestic Exclusion Order, which prevents the family member, the abuser, from entering either the victim's residence or at least parts of the residence. So this is regardless of the fact, say if it's a husband and wife and the husband is the abuser. Even if the husband is a joint owner of the house, this DEO can preclude him from entering the entire house or at least part of it, like a room, for which the victim can prohibit him from entering without her consent. So who are the family members a victim can obtain a protection order against? Number 1, the spouse or even ex-spouse. So technically, even though you might not consider the ex-spouse as a family member for the purpose of this application includes the ex-spouse. The next one is a child. The third one, parents-in-laws, siblings, or even any relative whom the court takes the view may be regarded as a member of your family. So what if it's, say, an ex-boyfriend or someone not related to you who is harassing or verbally abusing you? Now, that person is not considered a family member, but that doesn't mean you don't have recourse. You do, except that you are not seeking a personal protection order. Instead, you can seek a protection order under the Protection from Harassment Act. Now, if a victim applies or an applicant applies to court for a personal protection order, will he or she automatically get a personal protection order granted in his or her favor? No, not necessarily. The court has to be satisfied of two things. Number one, that family violence has been committed or is likely to be committed. So that would be based on the definition I had elaborated on earlier. And the second thing that the court has to be satisfied is that even though there's been family violence committed, that granting a protection order is necessary for the victim. So in other words, it's not the mere fact that family violence has been or is likely to be committed, it's whether it's necessary. So as an exaggerated example, if a husband physically hits a wife and then she applies for a PPO against him, but then decides to leave him and move overseas permanently where she would not be seeing him ever again, so it's unlikely that the court would find that a PPO is necessary in the circumstances because she'll be away from him for the foreseeable future. Now, what happens if a protection order is granted and the abuser continues to breach the protection order? The victim in such circumstances can lodge a police report, and this abuser may be fined up to $2,000 or imprisoned up to 6 months. If he's a repeat offender, he will be fined up to $5,000 or jailed up to 12 months or both. So if a family member disobeys the protection order, you should report it to the police as soon as possible. The police will investigate your complaint and decide whether or not the abuser should be charged in court or not for breach of the PPO or any other protection order granted to the victim. Here's the thing though. The one applying for the PPO or the so-called victim may not always be the victim. On many past occasions, as lawyers, we have seen cases where one party files for a PPO against another party, not because they genuinely believe that there's been family violence inflicted on them, but because they wish to have some leverage over the other party in ongoing divorce proceedings between the parties. So for example, if you have a wife applying for a PPO, sometimes it is the case that she's not always abused, but she wants to have some leverage over the husband. She wants to portray him as violent to get the upper hand for care and control of the children in divorce proceedings. In such a situation, the husband against whom this application is made should resist the application for a PPO and not just accept it lying down. It is also possible for a person for whom a PPO is granted against, so this abuser, to apply to have the PPO revoked at a later time in the future. So that's our bite-sized video on family violence. To those of you out there who are being abused, you do not have to suffer in silence. And to those who are victims of allegations, false allegations, the law is also here to help you. I hope this was beneficial to you, and I will see you in our next video. Bye-bye.